Thank you, Kim, and hello, everybody, and thank you so much for joining us. It's amazing to see so many people here. I'll just echo Kim's welcome to both members and non-members of the AOIC. We feel that we all need to collaborate on this really and work together as a unit. So we're very pleased to have this opportunity to give you a bit more detail on the progress we've made so far with the law reform, and importantly to share our thoughts, our concerns and our questions with each other. And of course, thank you also to Russell Sandberg for joining us again today. Russell's a real expert in this area of law, and he's spoken to us several times now, and each time he brings some fantastic insights. So we're really looking forward to hearing his thoughts on where we are with things. So we've talked quite a lot about these proposed law reforms in the past, and so today we won't be going into great detail on the specifics of the recommendations. However, if you don't know the background, please do have a look at the AOIC website and of course read the recommendations that the Law Commission has put together, because obviously it's important we all have that knowledge to back up what we're campaigning for. But today we're going to look at the practicalities of how these changes would affect us as working celebrants. In terms of the specific details, there are of course still many unknowns at this stage. But based on the very comprehensive proposals that the Law Commission's put forward, we do have a reasonable idea of what these changes would look like in practice. So we hope that this session will help you to evaluate the likely outcomes for you, for your business, and for couples getting married, importantly. So, Kim, I'm going to ask you, if you wouldn't mind, to just start the slideshow for me. Okay, can everybody see that? Can I just get a thumbs up if you can see it? Yep, fab.
Can you see the entire screen? Or can you see the...
Oh, no, I can't. If you click from beginning to start the slideshow.
There we go.
Fab, and now I just need to minimize this. Hang on a sec. Exit full screen. There we are. That's what I want to do. Okay, if you could go to the next page, please, Kim. Okay, so as I said, we're going to have quite a practical focus. First, we're going to consider what it would look like for us as celebrants if the government accepts the Law Commission's recommendations and includes independent celebrants as part of this. Then we'll cover what it will look like if they accept the recommendations but exclude independent celebrants. Russell is then going to discuss the other possibilities that the government may choose some other form of reform separate to what the Law Commission has proposed, or that the reform won't go ahead at all. And he'll also be reflecting on the fact that there will be an election next year and looking at the politics and possible implications of that. Okay, could we have the next slide, please, Kim? So first we'll have a very quick summary of what the recommendations are. So the Law Commission recommends that we move to an officiant-based system. So it would be the person conducting the marriage who would be licensed, rather than the current system where it's the building or location that needs to be licensed. Because of this, marriage ceremonies would be able to take place in a much wider variety of locations, including private homes and gardens, beaches, fields, etc. Under this new officiant-led scheme, the Law Commission's asking the government to consider the inclusion of new groups who could act as officiants. So if this reform goes ahead, then registrars and religious officiants would automatically be included, but a separate decision for government is whether independent celebrants and or non-religious belief officiants, such as humanist celebrants, could also be included. They also recommend simplifying the registration process for marriages and making it more consistent for all couples, regardless of who they choose to marry them, and giving couples greater choice over the content and form of their ceremonies. So that would mean fewer restrictions on religious, spiritual, and cultural content. Okay, can we have the next slide, please? Oh, we've done it. So in terms of the timelines, the Law Commission began its review in 2019. And in 2020, they published provisional proposals and underwent an extensive consultation process. So they had a lot of comments during that consultation that they had to consider. The final recommendations were then published and passed to the Ministry of Justice in July 2022. And we're now awaiting an interim response from government. Now, the agreement in place between the government and the Law Commission is that they will give an initial response within 6 months and a full response within 12 months. And if these timescales are not set in stone by any means, but it means that we are now overdue the initial response. So hopefully we're going to get that through any day now. Okay, so scenario 1, let's have a look at the first possibility, which is that the law reform goes ahead to move to an officiant-based system, and the government decides to include independent and humanist celebrants within the categories of authorised officiants. So in this scenario, we would be required to apply individually to the General Register Office, the GRO, to be authorised officiants if we wanted to be able to conduct legally binding marriage ceremonies. And just to note that this does only apply to marriages, not to civil partnerships. The GRO would then be responsible for approving these applications, and then once approved, they would be responsible for training and regulating us in the same way they currently do for registrars. And the Law Commission does specify that such training could be specific to the legal responsibilities associated with the role of being an officiant, rather than training and actually conducting ceremonies. Now, of course, it's inevitable that we'd need to pay a fee to be authorised, and a fee would probably also be payable for ongoing regulation from the GRO. But how much and how often that would be, we simply don't know at this stage. But we should note that this role would probably be open for anyone to apply for, so not just people who are already qualified celebrants. So imagine that the GRO would put some measures in place to prevent people applying just to lead one-off ceremonies for a friend, for example. Otherwise, you can imagine the administration for the GRO would be a nightmare. But technically, it does mean that anybody could apply. Okay, could we have the next slide, please? Thank you. So assuming we've applied and been approved as independent officiants, our ceremonies would then fall under the civil wedding category. In contrast, humanist celebrants would fall under the belief wedding category, because humanism is a belief system, and humanist celebrants would be trained and regulated by Humanists UK rather than by the GRO. As civil officiants, we would have freedom of content in ceremonies, as we currently do, but we would be required to include some prescribed words in order to legally marry the couple. We would still have relative freedom of content as long as the ceremony is identifiably civil. So, for example, it may include some spiritual or cultural content, but shouldn't be framed specifically as a religious ceremony. And the boundaries there is something that would need to be addressed as part of the detail of these new laws. We should note that in this scenario, registrars would also have more freedom of content. So the restrictions they currently have in place about not including any religious content would be substantially relaxed. But we can assume that registration services still wouldn't have the time or resources to fully personalise ceremonies and get to know couples as we do. So that does still give couples a big incentive to choose a celebrant over a registrar. So in terms of the legal responsibilities of the role, every couple would have a marriage schedule that would be given to them at the register office when they register their intent to marry. And then we would be responsible for signing these schedules during the ceremony and getting them signed by the couple and their witnesses. We would then be required to return the schedule to the register office, which I believe we would be able to do electronically, wouldn't have to be done in person. As authorised officiants, we would also have a responsibility for protecting couples against forced marriages and unregistered marriages, which is why the training and regulation that we would have from the GRO would be very necessary. These checks would, of course, mostly be handled by the register office, but we would obviously need to take that responsibility seriously, just as registrars currently do, and be on the lookout for anything that doesn't seem quite right. Okay, so that's a brief but we think realistic picture of what it could mean for us if this goes ahead to include independent celebrants. Although, of course, we're fully aware that the devil is in the detail, and a lot would need to be clarified in terms of how things would actually work in practice. So now we'll have a look at what this could look like if the government accepts the Law Commission's recommendations to move to an officiant-based system, but decides not to include independent celebrants as part of this. So in this scenario, our role would be unchanged in the sense that we can continue to offer non-legally binding wedding ceremonies. But the question is, how many couples would actually book us? And this lovely hand fasting picture I've included here is symbolic of the fact that in this scenario, we would be somewhat constrained. So under the new scheme, registrars would have much more freedom and fewer restrictions when it comes to including things like faith content. So if that was the only motivation for a couple choosing a celebrant over a registrar, then that motivation would no longer apply. But as I said, registrars are still not likely to have the time or resources to fully personalise their ceremonies and get to know their couples. When it comes to humanist celebrants, again, this would have been an extra decision, like an add-on decision for the government if the reform goes ahead. But we can be fairly sure that humanist celebrants will be included at some point down the road as authorised officiants. So the reason we can be fairly sure that this will happen is that a precedent has already been set for humanist marriage in Scotland and Northern Ireland. And in 2020, the High Court ruled that the current wedding laws do discriminate against humanist couples. And the only reason the judge didn't rule to authorise humanist marriage immediately was because of the ongoing Law Commission review and her reluctance to undergo more piecemeal reform of the law when that was going on. But given that the law was found to be discriminatory in the courts, it's safe to say that it's only a matter of time before humanist marriage is legally recognised. Now, that in itself is not a problem, and we fully agree that couples identifying as humanists should be entitled to a humanist marriage ceremony. But if humanist celebrants are authorised and independent celebrants are not, we can guess what will happen. And if we speak to celebrants in Scotland and Northern Ireland, we can see what's already happening. And that is that most couples who want to hold a legally binding and fully personalised ceremony will have to opt for a humanist celebrant, even if they don't actually identify as humanist. Independent celebrants may look to join Humanist UK in this situation to have a realistic prospect of keeping their job, although that would be dependent on whether you're actually humanist in outlook. And also, I imagine there would be barriers put in place in order to stop an influx of independent celebrants suddenly applying to be humanist celebrants. And that's completely understandable. But most importantly, because we need to keep the rights of the couple front and centre of our thinking, in this scenario, discrimination issues would still exist in marriage law, because we would basically be telling couples that to have a personalised marriage ceremony, they need to conform to the belief system of their officiant. And I'll leave you to make up your own mind as to whether that's appropriate. Okay, so Kim, if you could stop the slides there for now, I'm going to now hand over to Russell to talk us through a couple of the other scenarios and considerations. Thanks, Russell.
Thank you very much, Sophie. That was an excellent summary of the two kind of ideal types almost in terms of what could happen in terms of, I was distracted by the fact that there seemed to be some sort of thing on the screen. Of the two sort of ideal types of what could happen. I think it's worth just stressing, but at the moment, anything could still happen. It's fairly rare for the Law Commission to come out with something and then for it to be implemented to the letter, particularly in a situation such as this, where there was no draft bill. So in other Law Commission reports, they also draft a bill, which is how the law would look like, and then the parliamentary drafts people use that draft bill in order to start drafting the provisions. Here, what we've got instead is a 500-page, very complex, very thorough report. And so if the government did decide to go ahead with it, the first thing would be that the drafts people in the Ministry of Justice would start to work out what that would look like in practice. And every single nuance in the Law Commission's paper would then be up for grabs. And so it's entirely possible that even if sort of situation one is taken in terms of the government saying, yes, this is a fantastic Law Commission report, we're going to implement it in its entirety, it's still possible that even the first draft will look quite different from what the Law Commission envisaged. And of course, and I don't need to say this, as it would then go through Parliament, it would get amended significantly again. It's worth noting that this is not an uncontroversial law reform proposal, and that a good number, indeed the majority of respondents, replied to it negatively in terms of a strong Christian right lobbying campaign. So that also adds a further complication. It's possible that the government might respond by just going after the low-hanging fruit of humanist weddings, as it's possible they might do that without even then going any further than that in terms of reform. The discussions about humanist weddings have been ongoing now for the last decade. It's quite possible it might go on for another decade at this rate, or it might be seen as this is the opportunity to fix just that. It's possible that wider reform might be just kicked into the long grass. And it's possible that might even include the humanist aspect. So I think it's just worth bearing in mind here that there are a multitude of possibilities. And although we've just heard what would be the two sort of logical outcomes if the Law Commission's report is used, they are by no means the only potential outcomes. And I think that also gives independent celebrants room to look at this in two different ways. The first way is that is to look at this in terms of really arguing the case for reform, not focusing so much on the letter at the moment, but trying to argue that there is need for reform here, and this is the important bit, obviously, that reform needs to include independent celebrants. So there's that debate which needs to happen. And the more well-briefed MPs and journalists are prior to any movement at all from the government on this, that would be a good thing. The second thing to bear in mind, however, is that because the Law Commission's proposals are by no means fixed, that means the detail is contestable. And the Law Commission's view on this is very much based on an assumption that there is a dividing line between what religion and belief celebrants do and what independent celebrants do. And that is the dividing line upon which they talk about independent celebrants in the same breath as civil registrars, and humanist celebrants in the same breath as Church of England, clerics, ministers of religion of other groups. And that does have significant ramifications. It makes it more of, to use Sophie's language, an opt-on to include independent celebrants. It also robs you of the argument which Sophie was talking about towards the end, of the principled argument of why independent celebrants should be included. because the distinction being drawn by the Law Commission is that the religious and the belief celebrants are there so that people can manifest their religion or belief. And there's a human rights argument, which has been recognized by the courts, to say that that needs to be there. By contrast, independent celebrants have been put into a separate box. Now, I don't think that is right. And as Sophie was already discussing at the end of her presentation, I think an argument can be made. But if you want, if it's part of the person's human rights to be married in the way of their choosing, in a way that reflects their beliefs, then drawing the line at organized belief organizations is still discriminatory. It's less discriminatory, it has to be said, than the current law, which draws the line at religions. And even so, there draws the line at religions with a building. But nevertheless, that would still represent a line of inclusion and exclusion, and that exclusion would lead to discrimination. And so I think there's work to be done there in terms of eroding that distinction being drawn by the Law Commission, which I think might make it more difficult to get independent celebrants included, and B, might lead to problems down the line when different requirements apply to independent celebrants as opposed to humanist celebrants, because you're in two different camps. They don't look particularly onerous, the differences, it has to be said, based on what the Law Commission says. But of course, as I've said, there's no guarantee that any system would reflect what the Law Commission says. And as I've indicated before, I do think there's a much greater element of individual risk here for independent celebrants than there is for any other sort of celebrants recognised. Because if under this scheme, if I was a humanist celebrant, I would be subject to Humanists UK, who then would be subject to the GRO. Whereas if I'm an independent celebrant, I am directly liable to the GRO. And I think that poses some issues here. I think there's also an assumption by the Law Commission, which again can be eroded, that independent means individual. And, you know, that's obviously not necessarily the case. So what I'm saying is there's a whole range of potential options. So as long as this remains on the agenda, and as long as it remains on the agenda and included independent celebrants, and the Law Commission's work is incredibly useful there, then there's still room to fight over the details. And so the dividing lines we've just been talking about are not inevitable. The other thing, of course, which is not inevitable is, as Sophie flagged up earlier, the question of timing here. We are expecting, obviously, an election at some point next year. That means that there's not many more King's speeches of the current government. I would have thought that unless civil servants are currently working on a bill on this, it would be highly unlikely that we would see a bill in the next King's speech, which means realistically, I would have thought we are looking for progress on this in terms of the next government, whatever political colour that is. That, I think, is of importance in terms of, although obviously there's been a lot invested in the Law Commission's work, and that should continue in terms of highlighting what's happened, I think there's also a need to take a step back and to make the case anew for reform, and to try to influence that in terms of trying to get this into party manifestos, because that might be the way forward here. They then might go back to what the Law Commission has said and use that, even if not directly. The fact there's a body of work there showing how it's done will be of use. But I think this is one of those situations where the sort of day-to-day politics of this is also going to be of importance. And we've already seen that, you know, the 6-month ideal time or normal time in which you would expect an interim response has come and gone, as have several prime ministers at this point. And so all bets are off. And I think it's really, really important to not stop making the general argument that this is an area of law which simply doesn't work anymore. It simply doesn't work in 2023. It leads to all sorts of injustices, and also leads to a situation where there's discrimination, and also means that the economic benefits of marriages taking place, it doesn't fulfill its true potential. So just to sum up what I've been saying, and I'm keen not to go on for too much on this, we're going to talk a bit more about campaigns, but I'm keen to take as many questions and have the conversation going. But it's important not to assume that the way in which the debate has been framed by the Law Commission will be the way in which this debate is framed going forward. And as I say, and this might sound slightly pessimistic or optimistic, depending on your view of the Law Commission's report, all bets are still off. And I'll end there for now.
Thank you, Russell. Very useful, very interesting points there. And I think, you know, it really highlights that there are still a lot of unknowns, and we could still be in for a very long road ahead, probably will be in for a long road ahead. But I think, you know, we can use that time in our favour in order to get our points across. So I'm just going to spend another 5 minutes or so just talking about what the AOIC has been doing so far, the progress that we've made, and then we'll open the floor to questions. So Kim, if you wouldn't mind just sharing the slides again. Okay, so at the AOIC, we fully support wedding law reform and the inclusion of both independent celebrants and humanist celebrants. And we know there's a lot of support for this from individual celebrants as well, although I'm fully aware not everyone feels the same, and there are plenty of celebrants who would rather not see this change. But we feel that given that reform is inevitable in some form and at some stage, then we need to fight to make sure that we're not overlooked and that the discrimination issues for couples are completely removed. So the progress we've made so far with this campaign, and I should say we're not overly keen on the word campaign, prefer to think of it as more of a kind of wider conversation, but for want of a better word, that's what we'll call it. So far we've received a lot of support and backing from a number of different MPs. And in November last year, we held a successful MP reception in the House of Commons, where we had the opportunity to talk to various MPs about what this reform means. And that's something we may look to run again once we've received an initial response from the government and have an idea of what their thinking on this is. We're also part of the Weddings All-Party Parliamentary Group, APPG, and we're in touch with the MP who chairs that group, Siobhan Bailey. And she is also very supportive of our arguments. This law reform is going to be on the agenda at the next APPG meeting, and we're exploring several avenues in relation to that. But what's really quite frustrating is the lack of practical support that we've had from MPs. And it seems that getting them to turn their verbal enthusiasm into actual action is quite difficult. And that is understandable, as MPs are super busy people with huge issues to tackle. But the practical support of even just a small number of MPs could make a massive difference to our chances. Could we have the next slide, please? Thank you. Now, because it does prove such a struggle to get in front of every MP and get actionable support, we really do need the help of all celebrants who want to see this change. So if you'd like to be involved, we would suggest that as a first step, you make contact with your local MP or follow up with them if you've already had contact, and try to get a meeting in person, which you can either request or you can attend one of their surgeries. Emails alone tend to only elicit template and vague responses, so in-person meetings are much better. When you speak to your MP, as well as explaining your personal situation and the impact this would have on your livelihood, try to keep the discrimination and inclusivity issues at the heart of your argument. You can explain the benefits for couples in their constituency if you were able to legally marry them, and explain how constrained couples currently are in their freedom of expression, perhaps giving some specific examples of couples you've worked with. Because the upshot is that support from your MP could help to create a more inclusive system for couples in their constituency who choose to marry, regardless of their beliefs, outlooks, backgrounds and cultures. And next slide, please, Kim. Or is that the, hang on, no. You've already changed, haven't you? Yeah. So as well as putting your points across, there are a few specifics that you could ask them to help with if they're willing. So if your MP is a backbencher, you can ask them to raise this as a question in the House. So that question could be as simple as something like, when will the MOJ respond to the Law Commission's wedding law recommendations? And do they plan to include independent celebrants in future reform? I mean, really important. If we're asking them to ask a question, it's important we try and get them to mention independent celebrants specifically. You can ask your MP to write to the MOJ, putting your case forward, and I know several MPs have already done this. When they do this, you can definitely expect a very template and vague response from the MOJ. You won't get any detail. But I think it's still worth doing, because the more letters they receive from MPs supporting us, the more they'll realise who we are and realise that this needs addressing. And crucially, invite your MPs' ideas and opinions on this and ideas for moving this forward. Because of course they know how things work in the corridors of power much better than we do. So perhaps before we go in with our ideas that I've already mentioned, we can ask them what they would suggest doing to support this reform. And that was a kind of tactic we went for at our MP reception as well, you know, really listening to what their ideas were, and we got some very good ideas from them by doing that. We also have a working group of AOIC members who specifically meet around once a month to discuss wedding law reform and put actions in place. So if you would be interested in being involved in some way and helping out with that, then please do get in touch, as we'd love to have a few more members. Okay, final slide, please. And finally, if you support this reform and you haven't already downloaded this badge, you can find it on the AOIC website, and do feel free to use it on your websites and social media to show that you support the cause. It's a very small thing, but visual things like this do generate momentum, especially given how many celebrants there are. And they help to spread awareness that this process is still going on, hopefully encouraging those who see it to find out a bit more and get involved.